Good day, viewers, and welcome to Africa Pulse Network. Today's update is not the kind of court news anybody expected, but here we are again. On Monday, 8th December 2025, and the Federal High Court had Nnamdi Kanu's matter listed, even though he himself was not physically there. Instead, his brother Prince Emmanuel and the legal team appointed to represent him stood in for him as the court called the case. For those who may not have followed the earlier hearings, Kanu has been pushing for one major thing: a transfer from the Sokoto prison, or at least an order that would allow him to file his appeal properly from a court close to where he is being held. His argument is simple: the distance is blocking his right to appeal.
In the ruling of the Supreme Court, we're meant to understand that the security agencies messed up the whole thing. So there was illegality in the addition of Nnamdi Kanu back to Nigeria. The court acknowledged that. But I'm so shocked that he has also perfected the wrongs of the federal government. He recognized that we are wrong, and then why taking back the same case to the Federal High Court? What's the meaning of that? You put illegality on illegality. That's what it is. So I do hope that the world would rise up and speak now. Injustice to Nnamdi Kanu is injustice all over.
And without proper access, he cannot file the complete documents required to move his case forward. He already raised this issue earlier in the month, and the judge told him to return with his lawyer on the 8th. That is the day we are discussing right now. So yes, yesterday, Prince Emmanuel and the defense counsel stepped forward as the case was called. They were prepared to move the motion asking the court to either transfer Kanu or allow him to file from a closer jurisdiction like the Sokoto judiciary. They argued that since the notice of appeal has already been given, he needs access to complete the rest, especially the affidavits and required filings before the deadline. When the motion was finally moved, the court listened. But then Justice Omotosho pointed out something that changed the entire direction of the day. The prosecution was not present. The prison authorities were not present. And because of that, he refused to grant the request as an ex parte motion, which normally allows a judge to give an order in the absence of the other party. Instead, he insisted that the matter must become a motion on notice, meaning both the Sokoto Prison Service and the prosecution must be officially notified and must appear in court before he can rule. This instantly complicates what should have been a direct order. He then adjourned the case to 27th January 2026, giving time for the motion on notice to be filed and for all parties to respond. But here's the stressful part. Kanu's appeal deadline is February 18. That is exactly when the 90-day window closes. Anyone watching this closely can already see the tension. The dates are dangerously close. And to many observers, it feels like yet another strategic delay intended to frustrate Kanu's ability to complete his appeal on time. Let's be honest. The original sentence that sent Kanu to Sokoto remains one of the most criticized judicial decisions in recent memory. Lawyers, observers, and human rights voices call it one of the highest examples of judicial overreach, issued without regard to due process, issued without aligning with the Constitution, and even delivered in Kanu's absence after he was removed from the courtroom by the judge himself. Judges are expected to manage cases with maturity, especially high-profile ones. You cannot throw someone out of court simply because you feel uncomfortable with their presence. You cannot allow personal emotions to override the mandate of the law. Yet this is exactly what happened, and it is one of the reasons people insist the judgment was biased from the start. Now back to recent day. Legally speaking, an ex parte motion is allowed in cases where the other party is no longer directly involved. Since Kanu has already been convicted and the matter of his appeal concerns only his right to file documents, many believe the judge should have granted the ex parte request and ordered the prison to cooperate. Instead, he converted it to a motion on notice, meaning more delays, more complications, and more opportunities for the timelines to run out. Observers say this is why public trust continues to fall. You cannot take what is clearly a straightforward request and stretch it into an obstacle course simply because you can. It becomes abuse of office, and many believe that is exactly what has been happening. But hear the truth. The game is still on. Kanu has survived more complex battles than this, and he understands the system better than most people imagine. Whatever strategy lies ahead is known only to him, and that has kept him standing till this point. The real danger here is for the judge himself, because when someone in authority allows personal bias to influence judicial decisions, it eventually leads to self-destruction. That is how careers collapse and reputations disappear. We will keep watching, we will keep documenting. January 27 is dangerously close to the February deadline, and anybody can see the pressure building. For now, the fight is not over. Stay connected, stay informed, like and share, subscribe if you're new here, and turn on all notifications so you don't miss anything. We are Pota's Family International, a family of truth, purpose, and faith. And with faith, every mountain becomes movable. Until the next update, stay safe, stay strong, and remember, wherever you are, someone near you is your brother. Help when you can. Basil.